Josh Hawley chaired the Senate Judiciary Committee in an all-out attack on free speech and fair use. The hearing was called Too Big to Prosecute? Examining the AI industry's mass injection of copyrighted works for AI training, and it used AI training as an excuse to screech for the destruction of fair use protections that have been in place for a century. Remember, fair use is a fundamental human right based on our First Amendment right to freedom of speech, and several cases make this clear, including Eldred v. Ashcroft, Harper and Row, Campbell v. Cuff Rose, among others. By the way, this isn't the first time Hawley has used big tech as an excuse to destroy the Constitution. We've discussed previously his opposition of basic conduit protections as specified in Section 230. Understand, this is not something that's a response to the threat of AI. That's just the latest excuse. This assault on our digital rights from the copyright cartels goes back at least as far as Universal v. Corley. So let's listen to some of Hawley's remarks.
We're talking about piracy. We're talking about theft. For years, AI companies have stolen massive amounts of copyrighted material from illegal online repositories. But have these big tech companies been prosecuted? No, of course not. They're getting off scot-free.
But once again, the whole point of fair use is that if the use is fair, you don't need permission to obtain them. In fact, permission would completely negate the need for fair use. And we'll see as we go through a lot of the testimony that this is exactly what they want, to destroy fair use and to make 100% of all human output subject to the big content cartels. Just listen to it from Senator Dick Durbin's mouth.
Should AI companies be able to use their materials freely as, quote, fair use, unquote?
Hey, Dick! What's with the quote-unquote? Yes, he's trying to undermine the entire concept of fair use.
As Anthropic's CEO put it, Anthropic had many places from which it could have purchased, but it preferred to steal them to avoid, quote, legal practice business slog, whatever that means.
Lie, 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 lie! In fact, as I covered on my YouTube channel, plaintiffs acknowledged that there was no such licensing system, nor was one likely to form anytime soon. But regardless of that, Judge William Alsop found, quote, even so, such a market for that use is not one the Copyright Act entitles authors to exploit.
As a judge in the Meta case recently put it, quote, companies have been unable to resist the temptation to feed copyright-protected materials into their models without getting permission from the copyright holders or paying them for the right to use their works for this purpose.
Oh, you lying scumbag! Judge Vince Chabria actually said the same thing as Alsop, quote, this market is not one that the plaintiffs are legally entitled to monopolize. In every fair use case, the plaintiff suffers a loss of a potential market if that potential market is defined as the theoretical market for licensing the use at issue in the case. Therefore, to prevent the fourth factor analysis from becoming circular and favoring the rights holder in every case, harm from the loss of fees paid to license a work for a transformative purpose is not cognizable. Their witnesses included Max Pritt, one of the ambulance chasers at Boies Schiller that's suing Meta and who had no compunction about lying about the case at every turn, Mike Smith of Carnegie Mellon University, whose cherry-picked studies with bad methodology go against all of the other industry studies which show that piracy has no ultimate effect on sales, as we've covered several times, and arguably the worst of the lot, law professor Bhamati Viswanathan, whose dishonesty included crap like this.
If you and I stole books from the library or from a bookstore and said, I need to train, I need to learn, I need to develop my mind, we wouldn't argue that this is fair use.
Whereas not only the Copyright Act and the courts, but also the Copyright Office itself all say that a computer algorithm is not the same as a human being, and both judges ruled that ingestion by an algorithm is not the same as being read by a human. She engaged in a lot of the same kind of begging the question both judges argued against. For example,
But you don't go to pirate websites to get that material if what you want to do is legal.
Again, if it's fair use, it is legal regardless of how you obtained it. That's why it's fair use, not fair obtaining. Her whole argument throughout her testimony basically boiled down to using pirate sites automatically means you're guilty and you don't even bother with that pesky fair use analysis. And she even went against the established facts of the case.
At the same time, you can send them out. That's called seeding. You can send them out at the same time. Uploading and downloading exist at the same time. This is a peer-to-peer process. So not only are you taking in these pirated materials, you are also distributing them.
When first, that's limited to Meta and wasn't even alleged in Anthropic. And second, Meta detailed at least 3 ways they prevented seeding even while downloading. The first is that they turned off seeding in the client, and the second is they used several other settings, such as setting the upload bandwidth to 0 to prevent seeding while downloading. And the third, and this one really should be sufficient on its own, when they set up the firewall rules to allow torrenting, they only allowed incoming data. Any attempt by the client to upload any blocks, any attempt by anyone else to so much as even request them, would have been denied. Meta's expert, Barbara Fredrickson Cross, made that clear, and plaintiffs provided absolutely nothing to refute it. And since fact and expert discovery are both closed in the case, that's that. I guess these people are counting on us not knowing that. Well, at least listeners to this podcast are immune to their lies. There was a lot of fawning over New York Times best-selling author David Baldacci as well. Among all of their witnesses, they only had one actual expert who knew what he was talking about and who argued with anything other than bad analogies and emotional pandering. That was Edward Lee, professor of law at Santa Clara University School of Law. And he made several points that hit the nail right on the head. For example,
critically, in the cases against Anthropic and Meta, the judges concluded the plaintiffs did not show the models had produced any infringing outputs of the plaintiff's works.
And his was the only sane voice, arguing that at the very least, Congress should wait and see what happens in the courts first.
The United States National Priority in AI counsels caution. Indeed, in Google versus Oracle, another technology fair use case of national importance, the United States Supreme Court itself cautioned, quote unquote, given the rapidly changing technological, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the parties' dispute. At this juncture, I think the best approach is for Congress to wait and see how other district courts, the courts of appeals, and potentially the United States Supreme Court resolves these difficult issues, including access to pirated shadow libraries, in the many pending copyright lawsuits across the country.
So just listen to a bit of the questioning.
Even Justice Story in Emerson versus Davies recognized that not everything in a book is protected by copyright. Authors build on the past books to write new books, and that fuels creation. And here, the line that Judge Chabria and Alsop drew in terms of non-infringing output, there is no copyright claim in the production of non-infringing works.
It looks to me like you're shifting the burden to the author of the creative work when there's an assertion of fair use here. So Meta or others can virtually steal this creative product of Mr. Baldacci and others, and then he has the responsibility of proving that there's been an economic loss to him as a result of it?
Not at all, Senator. The judges explained in their opinions that, yes, the initial burden for fair use is on the defendant, but the defendants in both cases provided evidence that there was no output of infringing works. And the question then becomes, will the plaintiffs present contrary evidence? And neither judge found evidence of outputs that had substantially similar copies of the plaintiff's works.
But through it all, Hawley was the worst, with comments like,
What you mean to say is it may benefit American corporations. It may impoverish American citizens, but it will benefit American corporations.
As if he's the one on the side of the little guy and not simping for the big content cartels. And as if Meta didn't make their models open source so that anyone could use them, big or small. I searched through a transcript, and according to the transcript, open source wasn't mentioned once in the entire proceeding. The benefits to you and me were not only never mentioned, they were dishonestly denied.
They're coming to claiming fair use after they've stolen Mr. Baldacci's work. They didn't take it from the library. They didn't license it. They didn't buy it.
And if it's fair use, they don't have to. Again, that's the whole point of fair use.
It just sounds strange to me to say that the United States as a nation is going to benefit from the mass violations of its citizens' rights. I thought what made us a nation was our common citizenship, the things that we agree on together, the rights that we hold in common.
Yeah, except for those pesky ones like the First Amendment.
I want to live on a different planet if this can go on and it's perfectly legal.
Well, maybe we can arrange that.